regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad to be with you today and glad that you are with me. You know, the Supreme Court is still on its summer break. It's hard to believe that some schools are already back in session, but that is the case. The justices will not get back to D.C. for another couple of weeks. And when they do, there are going to be a number of Second Amendment cases awaiting them to consider in conference. One of those cases, the cert petition just filed a couple of days ago, and it is one of two cases dealing with bans on quote-unquote large capacity magazines that the court will have the opportunity to consider this fall. So Duncan versus Bonta, that's the case out of California where Judge Roger St. Benitez has not once but twice declared that California's ban on LCMs violates the Second Amendment. And not once but twice, the Ninth Circuit Court of Appeals has said, no, this ban is absolutely fine. So the cert petition in Duncan is due before the Supreme Court, I believe at the end of this week, August 17th. But there is another case that's in the Ninth Circuit's jurisdiction, but it's not a federal case. It's actually dealing with a decision from the Washington State Supreme Court, which takes on Washington's ban on large capacity magazines. This is a case where the Superior Court decided that Washington's ban violated the Second Amendment, as well as Washington State's protections for the right to keep and bear arms. But the Washington State Supreme Court, again, overruled that decision and said that, no, this ban is fine because magazines aren't even arms protected by the Second Amendment. Walter Wentz is the owner of Gators Custom Guns in Kelso, Washington. He is the one that challenged this law after he was accused of knowingly selling standard capacity magazines to undercover state regulators. Attorney Paul Clement is representing Mr. Wentz in this challenge to the Washington State's Supreme Court decision. Lee Williams over at the Gun Writer spoke with Wentz and has a story about this today. But I took a look at the complaint. We're going to be delving into the complaint itself here on the program. I got to say, by the way, I mean, I don't know if I'd call myself a Paul Clement fanboy, but I do appreciate not only the dedication that Paul Clement has shown to the right to keep bear arms. Remember, after the Bruin decision, he was told by his law firm, quit taking Second Amendment cases. He keeps winning them. But don't take any more of these cases. We don't really like it. And so Paul Clement ended up leaving that law firm, set up his own shop with attorney Aaron Murphy, and they've been continuing to do a lot of work in Second Amendment spaces, including, again, representing Mr. Wentz. So in this complaint, Clement and Murphy talk about this decision by the Washington State Supreme Court and how contrary it is to Bruin, to Heller, to the Supreme Court's Second Amendment jurisprudence. As they write, it should have been easy to see that this state law, ESSB 5078, violates the Second Amendment. And for the Superior Court below, he says it was. But after the Superior Court correctly concluded that Washington's ban violates the Second Amendment, the Washington Supreme Court reversed, holding that magazines capable of holding more than 10 rounds are not arms within the meaning of the plain text of the Second Amendment and therefore are not even presumptively protected. Indeed, he says the court posited that magazines are never protected by the Second Amendment, no matter their size. She says would mean that states could effectively ban semi-automatic firearms entirely without ever having to reconcile such efforts within our nation's historical tradition of firearms regulation. It might not be that states could ban semi-automatic firearms, but they could ban detachable magazines, making the capacity of a semi-automatic firearm one round. Under the Washington Supreme Court's decision, that would be just fine. There'd be nothing stopping an anti-gun state or state lawmakers from doing so. Now, Clement and Murphy also write that this decision by the Washington State Supreme Court, quote, deepens an acknowledged division of authority among federal courts of appeals and state courts of last resort over whether these ubiquitous instruments are arms that cries out for resolution. And it gets a profoundly important constitutional question profoundly wrong, arguing that the Supreme Court should grant cert and confirm that bans on the feeding devices needed to make constitutionally protected firearms work as intended, of course, implicate and, in fact, violate the Second Amendment. Now, in laying out his argument, Clement talks about the lack of a historic tradition in terms of regulating the capacity of firearms, noting that even in 1791, multi-shot firearms did exist. Whether or not they were in common use, I think is debatable. But, you know, even if you want to look at like 1868, right, the 14th Amendment, as the sort of, maybe not the primary, but maybe an ancillary time period in history where we can look at, okay, well, what did the national tradition of firearms ownership look like then, right? And what did the gun laws in place look like then? By 1868, multi-shot firearms were the standard. They weren't the exception. And yet there were still no attempts to limit the capacity of a firearm. And you could, again, argue that, well, you know, revolvers by their very nature are going to be limited to, 5 or 6 shots. But, repeating rifles were around in 1868. I'm going to paraphrase the motto of the Henry repeating rifle, but it was load on Sunday, shoot all week, right? So that was, I would say, if not the norm, it was certainly not uncommon to have multi-shot firearms by the mid-1800s. And yet again, there were no attempts to restrict the capacity of a particular firearm. As Clement notes, the first laws, state-level laws, restricting a firing capacity of a firearm didn't really take place until 1990. In a footnote, he talks about this. He says, before 1990, only the District of Columbia restricted law-abiding citizens' ability to keep or bear feeding devices of a particular size. D.C. law prohibited the possession of, in 1932, he says, Congress passed a local D.C. law prohibiting the possession of firearms that, quote, shoot automatically or semi-automatically more than 12 shots without reloading. That law, Clement writes, was not understood to sweep up ammunition feeding devices as an original matter. Indeed, he says, when Congress enacted the National Firearms Act, imposing stringent regulations on machine guns for the whole country just 2 years later, it chose not to impose any restrictions on magazines. Nevertheless, he writes, after the district achieved home rule in 1975, the new D.C. government interpreted that 1930 law so that it outlawed all detachable magazines and all semi-automatic handguns. Heller, of course, he notes, invalidated the latter portion. Indeed, and of course, Washington, D.C. would go on to ban not just semi-automatic handguns, but all handguns, a decision, of course, that was overturned in the Heller decision. As Clement writes, what the D.C. Circuit said over a decade ago remains true today. There may well be some capacity above which magazines are not in common use, but that capacity is surely not 10 rounds. You could conceivably make the case that, a 50-round magazine or a 100-round drum magazine, not in common use for lawful purposes. I don't know how many of those magazines are in existence. You could probably make a plausible argument that they are, in fact, in common use for lawful purposes. But magazines that can hold more than 10 rounds are undoubtedly in common use. In fact, even the Washington State Supreme Court acknowledged that they were common, but it didn't matter how common they were because the State Supreme Court decided that they weren't arms. So going back to the cert petition, Clement writes, this court, meaning the Supreme Court, has made crystal clear that the Second Amendment's definition of arms extends to all bearable instruments that facilitate armed self-defense. Yet the Washington Supreme Court did not ask whether the magazines that are outlawed satisfy that definition. In fact, it explicitly rejected that definition. According to the Washington Supreme Court, quote, not all instruments that may plausibly be used for self-defense are arms, So Clement says, despite having professed adherence to the United States Supreme Court precedent that gives meaning to the plain text of the Second Amendment, the Washington Supreme Court then forged its own path, asking not whether the magazines that Washington has outlawed facilitate self-defense, as Bruin and Heller requires, but whether they are, quote, designed as weapons, which is not anything that the Supreme Court has said. He goes on to say that the majority of the state Supreme Court also rejected the assertion that the magazines that are prohibited under Washington law are integral components of firearms. The majority did not deny that a semi-automatic weapon will not function as intended without a magazine, nor did it dispute that because certain types of firearms require the addition of a detachable magazine to function, a magazine is an integral component of such a firearm. But because, quote, no firearm requires a magazine of this particular capacity to function, the majority held that so-called large capacity magazines are not arms at all. And Clement notes that while the Supreme Court could have stopped there, instead, the Washington State Supreme Court, quote, went on to opine that large capacity magazines also fall outside either protection of the right to bear arms because the provisions protect only those arms that are commonly used for self-defense. He goes on to say the majority do not deny that large capacity magazines are common, that they are typically possessed by law-abiding citizens for lawful purposes. It just held that it made no difference. According to the majority, what matters is what large capacity magazines are actually used for. And of course, again, that flies in the face of what the Supreme Court has said. The Supreme Court has said that the Second Amendment protects arms that are in common use for lawful purposes, including self-defense, but not limited to self-defense. If that was the case, if the Second Amendment only protected those arms that were used, again, were in common use for self-defense, that would mean that bolt-action rifles could be banned. That would mean that, your turkey gun could be banned. And in fact, we actually have seen, I believe it was, it was a judge on the East Coast. I don't want to get the name wrong, so I'm not going to call it a name, but I think it was a Connecticut case in which a judge essentially made that decision, concluding that, the only guns that are protected by the Second Amendment are guns that are commonly used for self-defense, which is funny because, 20, 30 years ago, the gun control groups would have argued that, no, everything but handguns are protected by the Second Amendment, or semi-automatic rifles, right? The bolt-action, lever-action, maybe a revolver, pump-action shotguns. Maybe those are protected by the Second Amendment, but anything that's primarily used for self-defense, like a semi-automatic handgun, no, absolutely not protected by the Second Amendment. Both of those extreme positions are wrong. The Second Amendment, the plain text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. It doesn't say to keep and bear arms in self-defense. It doesn't say to keep and bear arms for hunting. It doesn't say to keep and bear arms for competitive shooting. There really is no limitation placed on the why people own arms related to our right to keep and bear them. Again, the Supreme Court has said that, all right, arms that are in common use for lawful purposes are protected by the Second Amendment. But they've also noted that, handguns are the most common gun used in crime. They're also the most common handgun or common gun used for self-defense. So it doesn't matter if they're popular among criminals because they are being used by Americans for lawful purposes, such as protecting themselves and their families. But in no way, shape, or form did the Supreme Court limit the exercise of our Second Amendment rights to self-defense. That is one of the activities that is protected by the text of the Second Amendment, but it is not the only activity that is protected. So the Supreme Court, had the opportunity to take up a magazine ban case last term, right? Actually, I think it had a couple of chances, but the one that immediately comes to mind was Ocean State Tactical versus Nerona, the challenge to Rhode Island's ban on quote-unquote large capacity magazines. Now, that was an appeal of a denial of a preliminary injunction. So that case is yet to be fully tried on the merits. So it'll go back up before the Supreme Court at some point, presuming that the court has not already addressed this question. Gator guns, has been fully briefed and tried on the merits. There is no other option for Walter Wentz other than an appeal to the U.S. Supreme Court, because the Washington State Supreme Court has weighed in. So he can't go file I guess he could file a new federal lawsuit starting at the U.S. District Court, working his way up to the Ninth Circuit Court of Appeals. But he can also directly appeal the state Supreme Court's decision to the U.S. Supreme Court, which is what he's done. And that is the standard practice when a case has been denied by a state Supreme Court. Then you've got, again, the Duncan case out of the Ninth Circuit, dealing with essentially the same question, but another jurisdiction. And, again, U.S. District Judge Roger Benitez held before the Bruen decision that this ban violated the Second Amendment. Duncan was one of those cases that was GVR'd by the Supreme Court after Bruen. So they sent the case back down to the Ninth Circuit for further review. The Ninth Circuit then kicked the can all the way back down to Judge Benitez in an attempt to delay consideration of this case by the Supreme Court. Benitez once again found that, these magazines are protected by the Second Amendment. Nothing in Bruen changed that fact. Ninth Circuit again decided, no. These aren't protected by the Second Amendment. And so the court will have multiple opportunities. They could either consolidate these cases, they could take one, they could reject the other. But they will have the opportunity to address in the very near future whether or not the hundreds of millions of magazines that can hold more than 10 rounds that are currently possessed by lawful gun owners are in fact protected by the Second Amendment, are in fact arms, or whether, again, states like California and Washington could impose bans not just on magazines that hold more than 10 rounds, but magazines that hold 5, 4, even 2 rounds of ammunition. That's the question that's before the Supreme Court, and hopefully this is, I'll be honest with you. After Snope, I'm not confident that the Supreme Court's going to take any case, but this is an issue that the Supreme Court really does need to address, and will have a couple of good vehicles to do so come this fall. All right, let's turn our attention now to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Kentucky. The headline by the New York Post: Mom, kids allegedly abducted at knife point by career criminal who was out on shock probation thanks to a Democrat-appointed judge. Yeah, this is a bizarre story. So as the New York Post reports, a career criminal who allegedly kidnapped a mom and her 2 young children and forced them at knife point to help him rob a Kentucky bank was released from prison just a year earlier after a Democrat-appointed judge granted him shock probation. 32-year-old Armand Langford allegedly broke into the family's home in East Louisville last Friday, forced the woman to drive him to a bank where he demanded $20,000 from a teller working the drive-thru. Langford held a knife to the woman's throat during the ordeal, then stabbed the mom in the abdomen and ran off, leading police on an hours-long manhunt before he was arrested. Brandon Strong, who is the woman's husband and the father of the 2 kids who were also abducted, talked about his disbelief and anger after learning that Langford had been sentenced to 14 years in prison last year after he was convicted of nearly a dozen robbery charges. But he was then sprung by Judge Jessica Green, who was appointed as a Jefferson County Circuit Court judge by Kentucky Democrat Governor Andy Beshear after just 5 months in July of 2024. Strong telling Fox and Friends, it's unbelievable that this was allowed to happen. This was not a guy running red lights. But the judge cut him loose on shock probation, which gives offenders a second chance after they spend a short time behind bars. The idea being that, again, that shock to the system of being put in prison will deter them from committing crimes in the future. Brandon Strong says the whole entire judicial system that made this decision needs to go away. How would that shock probation be an option for somebody who is a violent criminal? Well, that's the whole point, right? Is that the idea is that these violent criminals are going to be shocked by spending time behind bars, that they don't have to spend a lot of time behind bars to change their ways. The problem with that is that a lot of violent offenders are going to say, oh, well, that wasn't so bad. 4 months for, 5 months for committing, 12 armed robberies. It's kind of worth it if I even get caught, right? I am not a fan of shock probation. I am not. Particularly not for violent offenders, but in general, I'm a big fan of truth in sentencing. If somebody gets sentenced to 14 years in prison, they should do 14 years in prison. It shouldn't be, a day off for every day that they don't assault a corrections officer. It shouldn't be, well, we're going to sentence you to 14 years and then we're going to immediately stay 12 of those years and put you on probation. No. 14 years should be 14 years. But it definitely shouldn't be 5 months, which was the case there in Kentucky. Today's armed citizen story from North Carolina, where police say a shooting in Winston, Salem was an act of self-defense. This happened, I believe, over the weekend. We don't have a lot of details here. Winston-Salem police says that 54-year-old Hayes Godfrey Miller confronted a man with whom he had an ongoing dispute outside of the man's residence around 10:15 Saturday morning. According to investigators, Miller acted in a threatening manner while holding a gun, and the resident who Miller was confronting ended up shooting him. Officers arrived to find Miller on the ground with gunshot wounds, administered aid until EMS transported him to a hospital where he later passed away. According to WFMY News, police say that evidence indicates the shooting was done in self-defense. After consulting with the Forsyth County District Attorney, no charges will be filed at this time, although they do say the investigation is ongoing. Again, don't have a lot of details, but if police concluded that this homeowner had a reasonable fear that his life was in danger, then yes, he did have the right to defend himself on his property. So we'll keep our eyes out for any more details, see if they become available here. Finally, today, our good deed of the day, in the right place, at the right time, willing and able to do the right thing. A Harrisburg, Pennsylvania man who was able to render aid to a fellow patron at a pool hall in Harrisburg. Again, talk about being in the right place at the right time, right? Rick Leitner collapsed to the ground at the Club Med Billiards pool hall, and Bernard Richards was there to save his life. Richards said that Leitner's face was turning blue, didn't hear a single breath. Leitner said he was just trying to make his next pool shot when all of a sudden he started feeling lightheaded. He said, the last thing I remember was kneeling down, and then I collapsed on the floor after that. He said one of the players asked, does anybody know CPR? And Bernard stepped up to the plate. Richards says this was his first time he's ever actually had to administer CPR. He says, thank God I had a really good CPR trainer. And he said, and the one thing he told me was, don't worry about hurting that person. That person's already dead. He said, Rick doesn't remember this, but he actually woke up twice. So Bernard Richards performed chest compressions. Police were called quickly. They got to the scene within 10 minutes. They had an AED, so they were able to shock Rick Leitner's heart. Richard said he didn't realize that he saved Leitner's life until he got a voicemail from him about 6 weeks later. And the pair were able to reunite recently. Richard said he doesn't regularly play pool hall. He doesn't regularly play pool. He was just at the pool hall with some friends when Leitner went down. But again, in the right place at the right time, willing and able to do the right thing. Bernard Richards, we thank you for your life-saving deed. All right, that is going to do it for this edition of Bearing Arms Cam & Company. And just a programming note, the producer Jim is actually going to be out tomorrow and Thursday, so we will not have a show. I'm actually going to be stepping away from the website tomorrow as well. I've got to take one of my kids to college orientation, so that'll be fun. But I will be back behind the keyboard on Thursday. And then because we're not doing a show Wednesday or Thursday, we will do a special Friday Bearing Arms Cam & Company. I'm going to be talking with Rob Dorr from the Minnesota Gun Owners Caucus. A couple of interesting things going on there. There's an interesting court decision dealing with unserialized firearms, but also anti-gun bias in academia, a sterling example of this. I think I'm going to actually write up a piece about this at Bearing Arms, the website, today, but we're going to be talking more about it with Rob from the Minnesota Gun Owners Caucus on Friday, so I would encourage you to tune in for that. And again, meanwhile, check out BearingArms.com throughout the day today. Tom Knighton's going to be holding down the fort for me tomorrow. I'll be back again at it on Thursday. Every day, we've got you covered for the latest news regarding your right to keep and bear arms, the successes, the threats, and even the setbacks. We're talking about it all there. If you like what you see, I would encourage you to become a VIP, VIP Gold, or VIP Platinum member. Use the promo code FIGHT, and you can get 60% off your VIP membership. You get all kinds of great perks, no matter what level of support you choose. And no matter what level of support you decide on, we really do appreciate that support. Thank you very much. Have a great rest of your 2A Tuesday. We will see you back here on the show on Friday. And again, be sure to check out BarryandArms.com in the meantime. Till then, be well, be safe, and be free.